Hello, welcome to this live discussion on the Kulbhushan Jadhav case, which has taken a new and in many ways rather unexpected dramatic turn, with India approaching the International Court of Justice on May 8th, requesting not just the intervention of the ICJ in the matter concerning the death sentence awarded to Jadhav, who is a retired naval officer accused of espionage by Pakistan, but also asking for immediate relief in the form of the president of the court invoking his powers under the ICJ statute to get Pakistan to essentially hold off on the execution of Jadhav. The government of India says that there was a sense of urgency around this because although the Pakistani side said that Jadhav had been sentenced to death on April 10th, right? That was the date when the ISPR, the media arm of the Pakistani army, tweeted the news of the imposition of a death sentence on Jadhav. But India has no way of knowing, and certainly Jadhav's family has no way of knowing when exactly the death sentence was pronounced by the Field General Court Martial. And this is important because, as with any legal process, and Pakistan says that even in this case it is following due process, there is a timeline involved whenever somebody is sentenced to death, a fixed number of days that a person has to appeal before the Supreme Court or to move a clemency petition or to ask for a pardon. And in this case, the Pakistani system is quite similar to the Indian. There are various layers. Of course, he has been convicted not by a civilian court but by a court martial. And there's no telling when the time frame might suddenly creep up upon Jadhav's family and on India, and it might end, and we might find that Jadhav gets executed. So I think it was to forestall that kind of a sudden development that the government of India decided to approach the ICJ. The ICJ, for viewers who may not be familiar, is the world court. It's the in a way judicial arm of the United Nations, and is located in The Hague. Every member of the UN is a member of the ICJ, and when they sign up for the ICJ, they essentially chart out subjects and areas or circumstances under which they would be willing to subject themselves to what is called the compulsory jurisdiction of the court. Right? So it's not that any two members or any country can simply file a case against another member. The big question is, will the court have jurisdiction? And in order to answer that question, we need to establish that the country that you want to proceed against, when it signed up, when it signed up to the ICJ's jurisdiction, had allowed itself to be taken, to court by another country on the under the circumstances that the prosecuting country or the country that files a complaint wants to do. So, if you get into the minutiae of jurisdiction, the first question that every international lawyer has to ask, the first question that the judges of the ICJ will ask, is to what extent is the court does the court have jurisdiction to even hear India's case? And essentially, once the court decides it has jurisdiction, it proceeds in looking at the substantive case that is filed before it. But sometimes when there is a danger that swift action by the court might render an eventual judgment infructuous, the court and the court's president are empowered under Article 74 of the ICJ statute to request a member state to act in a way that would not prejudice the final outcome of the trial. And that's essentially what the president of the court, Ronnie Abraham, French judge, there are 15 judges in all at the ICJ. Dalveer Bhandari is from India. He's one of the 15 judges. And essentially, Ronnie Abraham, the president, wrote to Pakistan requesting that they act in such a manner that that an eventual ruling on India's request for the ICJ to examine the manner in which Kulbhushan Jadhav was sentenced to death is not rendered infructuous. So that's broadly the terrain. I am here to answer questions that readers and viewers may have on this case. You can simply ask your question by entering a comment below the video window that you see, and if time permitting, I will try to go through as many questions as I can to answer, to address some of the issues or concerns that our readers or viewers might have. So I'm just going to look at the page and see if there are any questions at present, and if not, and if there are, I will try to answer them. Otherwise, I'll give you a bit more background. So there is a question asked by Funny Sharma, who says, is the ICJ thing just a facade to buy some time and initiate a proper blame game if the execution is carried? So I think that I would say that the ICJ, the approach is not a facade. I think there are substantive issues of law that the Kulbhushan Jadhav case and the Pakistani handling of the case have raised. And I just want to spend a few minutes to explain what India's argument is and why this is a case that the ICJ really ought to hear. Broadly speaking, the facts are well known. Jadhav is, according to the Indians, a retired naval officer. According to the Pakistanis, he is a serving naval officer. The Indians say that he, after having retired from the Navy, Indian Navy, started work as a businessman and was in Iran on business. When he was kidnapped by people acting on behalf of Pakistan and pulled across the border, the Iran-Pakistan border, and then arrested in Balochistan, where he was subsequently presented as a spy, as somebody who had engaged in acts of sabotage and terrorism. The Pakistanis claim that Jadhav is an Indian intelligence operative. They say that he has confessed to being to working at the behest of RAW, which is the Indian External Intelligence Agency. They claim that he was apprehended inside Pakistan in Balochistan at the beginning of March 2016. They claim that he made a confession. They showed a videotaped confession, which when and how and the circumstances under which it was made are not clear. The video itself shows a lot of jump cuts, a lot of editing, which suggests that some effort went into trying to make the video as credible as possible. To my viewing, it does not appear particularly credible. A lot of what Jadhav said is obviously has to be discounted because of the circumstances under which it was under which he said those things. But broadly speaking, the dispute with India and Pakistan concerns the arrest or capture of Jadhav, the so-called confession, but most importantly, Pakistan as a signatory to the Vienna Convention on Consular Relations, which is a 1963 international treaty which governs the conduct of embassies and consulates around the world. It essentially spells out the duties and obligations of countries when it comes to dealing with diplomatic representatives. Hi, and welcome back to this live discussion on the Kulbhushan Jadhav case and the International Court of Justice. I apologize for the interruption, but essentially when we broke, we were discussing the reasons why India has moved the ICJ in this matter. Question was asked by somebody as to whether this is simply delaying tactics, whether this is some kind of a ploy or a ruse, and I'm arguing that in fact there are substantive questions of law that are involved here. And the point of law essentially is this, that Pakistan is a signatory to the Vienna Convention on Consular Relations, under which it is obliged to provide consular access to Indian diplomats stationed in Islamabad. They should be allowed access to Jadhav, who is an Indian citizen in their custody. Despite India asking Pakistan repeatedly over the last year, something like 16 times, for access to Jadhav, this access was denied, and India contends that this is a violation of the obligations of Pakistan under the VCCR, the Vienna Convention on Consular Relations. The Pakistani response has been that, well, Pakistan wrote to the government of India saying that we can consider giving you consular access if you cooperate with our investigation, meaning the Pakistani investigation into whether Jadhav is a spy or not. Prima facie, there is no reason for Pakistan to have connected its obligation under the Vienna Convention to provide India consular access with its request for cooperation in its own investigation. And India has in fact cited this linkage that Pakistan made to the ICJ as evidence of Pakistan's disregard for the VCCR. The Pakistani government also cites a 2008 bilateral agreement between India and Pakistan on consular access to prisoners, and there Section 5 or Article 5, Clause 5 of the agreement, and I have the agreement before me. Clause 5 of the agreement says that, Clause 6 says that in case of arrest, detention or sentence made on political or security grounds, each side may examine the case on its merits, right? So essentially Pakistan is saying that as far as we are concerned, this is an arrest made on political or security grounds, and whatever the Vienna Convention obligations of Pakistan may be, we are going to be governed by the bilateral agreement where India itself conceded that it's up to the government concerned to take a call based on the quote-unquote merits of the case. Now, this is a claim that Pakistan has made at a press conference. The Pakistani Foreign Affairs spokesperson essentially gave this as a reason why Pakistan is not sticking to its Vienna Convention obligations. And in its written submission to the ICJ, the government of India takes this claim of Pakistan head on. It essentially makes a legal argument that the 2008 agreement, even if it amplifies or expands upon the commitments of signatories to the Vienna Convention, it cannot derogate from, it cannot take away from obligations that both countries willingly and voluntarily signed up to adhere to. Right? So essentially India says, look, the 2008 agreement is fine, but it has validity only if it is implemented by both governments in a way that is consistent with their international obligations as far as the Vienna Convention on Consular Relations is concerned. It's a legal argument that the government of India makes in its written submission. Clearly, this is something that will be litigated, will be challenged by Pakistan. But the important point is that India has got its foot inside the door. The president of the court has requested Pakistan to hold off on the execution. And what India has done is to essentially ensure that Pakistan will have to turn up at The Hague and engage with India on the arguments that India makes before the court. So I think that this is an important issue. It's not as if countries have not argued before the ICJ about the implications of denying consular access in the past. There have been two famous cases, both involving the United States, where the US essentially violated its obligations under the Vienna Convention, in one case involving a German prisoner, in another case involving a number of Mexican prisoners, all of whom were sentenced to death eventually. And in both cases, Mexico and Germany successfully argued before the ICJ that the US had violated its commitments, and the court directed the United States to re-examine these cases in light of its ruling. So that's essentially the kind of outcome that India would be looking to obtain from the ICJ through this process. So I wouldn't put it down as to use Funny's words, something that this is a delaying tactic. I think that India very much, having exhausted all possibilities at the bilateral level in convincing Pakistan to abide by its obligations, has resorted to the ICJ, which is a forum that is available to it. And I should add that this is only the second time in India's history that we have decided to initiate a case at the ICJ. India has been before the ICJ on 1 to 5 occasions in all. So hang on a minute, with Portugal once, and with Pakistan 1 to 3 times. So this is the 5th occasion that India, we have been before the ICJ already on 5 occasions. Portugal moved the court in 1955 when India denied transit rights to Portugal between its then colonies of Goa and Daman and Diu. That's the case India won. In 1971, India took Pakistan India challenged Pakistan's attempt to involve the International Civil Aviation Organization, ICAO, in questioning an overflight ban that India imposed on Pakistani aircraft between the two wings of erstwhile West and East Pakistan. That was a case that, the only case until now that India had initiated. In 1973, Pakistan took India to the ICJ over the question of whether India had the right to put on trial Pakistani prisoners of war. And in 1999, Pakistan again took India to the ICJ over the shooting down of a Pakistani plane over the run of Kutch. In that case, in 1999, the ICJ decided that it did not have jurisdiction to hear the case. And finally, last year, 2015 and 2016, the Republic of Marshall Islands in the Pacific took India and other nuclear weapon states to the ICJ, alleging that these countries, including India, were in violation of their obligations to pursue nuclear disarmament in good faith. That was also a case where the ICJ ruled that it did not have jurisdiction to hear a case against India. So this is in many ways, from a diplomatic and legal point of view, a dramatic development. India, for only the second time in 70 plus years, opting to go to the ICJ and initiate a case. And in many ways, this is a bold step, but a step that has really been forced on India by Pakistan's refusal to abide by its obligations on the Vienna Convention. There's a question now from Padmaja Venkatraman. In the long run, will interventions by international organizations deter bilateral resolution of issues, or do you think it is vital that organizations keep stepping in to prevent further escalation of tension? I think this is a good question, Padmaja, but I think the issue, this revolves around what kind of intervention we're talking about, right? If the intervention is in keeping with the obligations of the parties concerned, then I think that external mediation or external arbitration or external adjudication can have a very positive impact on dispute resolutions. Just to give you a few examples, the Indus Water Treaty that India and Pakistan signed in 1955 has an inbuilt dispute resolution mechanism where essentially in the event of major disagreements, both countries agreed to have their differences resolved through arbitration. And there is a complex mechanism for selecting the arbitrators, but essentially once the arbitrators hear a complaint one country has against the other, and typically it's been so far Pakistan complaining against India as the upper riparian state, the judgment of the finding of the arbitrator is binding on both countries, and whatever the political rhetoric about the Indus Water Treaty in both countries, one could easily say that this treaty and its dispute resolution mechanism have stood the test of time, precisely because this was something both countries voluntarily entered into. I would say the law of the sea, arbitration sort of mechanism is something which again has produced very positive effects. India and Bangladesh agreed to have their maritime boundary delimited by an arbitral tribunal of the International Tribunal of the Law of the Sea. And even though that judgment in a way went against India's own claims as far as the maritime boundary was concerned and found more in favor of Bangladesh, the implementation of this agreement has gone smoothly because this is something that both countries voluntarily entered into. If you have, however, mediation that is not wanted by either side, or by one side and is wanted by one side and not the other, clearly that kind of mediation would take on a political character and would find no takers. So the reason why, say, the India-Pakistan dispute or the Kashmir issue has, India has never favored, or the reason why I would say as an analyst that external mediation would have really no role to play is because India is dead set against it. And without the political buy-in from India, without India being convinced that arbitration on an issue like that would produce a fair result, would produce something that would be in keeping with India's constitution, would be something that is in keeping with the aspirations of the people of India, the people of Jammu and Kashmir. The government of India is not going to accept that kind of mediation. Pakistan, on the other hand, would say, look, how do we know what the aspirations of the people of Jammu and Kashmir are? India is obliged under the UN resolutions to have some kind of plebiscite. So, there is a political dispute there, and I don't see how an external mediator imposing their services when one of the two parties does not wish to have them there can produce any kind of a positive impact. So I think that's the reason why external mediation, when it is not welcome, can actually create more political competition. This dispute, the Jadhav case, is one where both India and Pakistan, when they acceded to the Vienna Convention and also to the optional protocol, essentially agreed that disputes over the implementation of the Vienna Convention would, they would subject themselves to the compulsory jurisdiction of the ICJ. And so this is a great case where both countries voluntarily and willingly signed away their objections and have, agreed to subject themselves to the findings of the ICJ. And I think that this is a great moment, in that sense, for the development of international law as a dispute resolution mechanism. There's a question from Vijay Bhaskar. Do you think Pakistan will obey the ICJ order either out of respect or out of compulsion? What options does the country have? Vijay Bhaskar, that's a good question. I would say that if you read the request sent to the government of Pakistan by Judge Ronnie Abraham, who's the president of the ICJ, it's couched in very, it's not peremptory, there's no order, there's no demand being made of Pakistan. It's essentially couched in the language of a request, where the judge, the president of the court, says that under Article 74, I have the authority or the power to request member states to not act in a way that would prejudice the outcome of an eventual case, and we request you to abide by that. The reputational loss that Pakistan would have to bear in the event of its violating this request, I think, would be enormous. It would far outweigh any security, political, diplomatic, or strategic benefits that it believes it may get from executing Kulbhushan Jadhav. So my sense is that at the end of the day, rationality and common sense will prevail. Pakistan has a professional foreign office, and I don't think that Islamabad has anything to gain from defying this kind of an order, this kind of, I wouldn't call it, this kind of request from the ICJ. Later, when you have oral hearings and when you have oral arguments, the court may come up with firmer findings that in a way are more, that are couched in a more imperative language. But I would imagine that Pakistan today would be debating its legal options, and its lawyers would be arguing to its government that, look, we have a strong legal case. Just as India argues that the Vienna Convention obligations of Pakistan trump the 2008 bilateral India-Pakistan agreement on consular access, I'm sure there are lawyers on the Pakistani side who would say that, look, the bilateral agreement gives Pakistan a way out. And, ultimately these arguments have to be tested before the ICJ, which is the highest judicial body that the world has. Pakistan will get to nominate what's called an ad hoc judge, which in a way will balance out the fact that India has a judge on the ICJ, Judge Dalveer Bhandari. But eventually what the court decides is something that would be binding on Pakistan, because it accepted excuse me, because it accepted compulsory jurisdiction, the compulsory jurisdiction of the court in the first place in cases like this. Excuse me. Hasib Rahman asks, can Pakistan punish Kulbhushan and go against the ICJ, and what will happen next? As I said to the previous question, I would imagine that the diplomatic and reputational cost to Pakistan of defying the ICJ and implementing the verdict of the court-martial would far outweigh any benefit. So I'd be very surprised and even shocked and horrified if Pakistan were to show such a gross misreading of the diplomatic and legal terrain as to go ahead and do that. Rajiv Yadav asks, is the media playing into BJP and RSS propaganda by blowing the issue out of proportion, especially when thousands of civilians and defense personnel are killed every year in India? I don't agree with you, Rajiv. This is not a BJP RSS issue. I don't think this is a propaganda issue here, quite frankly. There is the life of an Indian national in Pakistani custody which is at stake. This is a national who has not been given access to Indian diplomats, so Indian diplomats have not been given access to him, as is as Pakistan is obliged to do. And every case, every violation of law, has its own gravity, its own specificity. nothing is gained by comparing the plight of Kulbhushan Jadhav, who has been in the custody of Pakistan for more than a year now, without access to lawyers of his own choosing, without access to his own country's diplomats. We have not heard in an environment free from coercion Jadhav's version of events. I'm sure he has an explanation for why he wasn't ended up in Pakistani custody, and I think the fact that Pakistan doesn't want to give us access, maybe because it knows the kind of things that Jadhav may reveal once he feels he is free enough and secure enough to give his version of events. So I think that this is an important case. It's an important obstacle in India-Pakistan relations, and I would urge you and other people not to look at this as through the lens of domestic politics. Sure, politicians and political parties will use issues that they can rake up for political gain, but here the law involved is complex, and I would imagine that law is what is driving the government of India at this point. I should recall for our readers that 2 years ago there was the issue of whether India should move the ICJ in the case of the torture and mutilation of Saurav Kalia, who was a young Indian army officer who was captured by Pakistan during the Kargil War of 1999, and when his body was returned to India, it showed marks of having been tortured. This was mentioned by the government of India at the time, and Captain Kalia's family has insisted all these years that Pakistan should be held to account, and they litigated this matter to the Supreme Court, where the Supreme Court requested the government of India to look into filing a case before the ICJ. But the law and the manner in which India and Pakistan have acceded to the jurisdiction of the ICJ clearly precludes India raising the Saurav Kalia issue before the International Court of Justice, which is why that case never progressed any further. But in this case, because Pakistan had agreed in advance to allow disputes with other countries over the implementation of the Vienna Convention to be heard before the ICJ, this is a golden opportunity for India to test the implementation of the Vienna Convention, to test how strong a case it has, and to see whether at the end of the day this legal move can end up sparing the life of a man that government of India says is innocent of all the crimes that he's been charged with. So I think that this is an important case from the point of view of diplomacy, from the point of view of international law, and we shouldn't look at it as something which is driven by domestic political considerations. There is a question by Yug Sinha. Violation of Vienna Conventions on Consular Relations, Geneva Convention, Optional Protocol, ICCPR by Pakistan can lead to, I'm not sure what the question is, Yug. And you also ask, don't you think India should cut down all its diplomatic talks and some military action must be taken if Pakistan rejects the request? Well, no, I don't think that cutting diplomatic ties or downgrading relations is the answer, because it's precisely at moments like this, when you have a crisis, that you need to have channels of communication open. And not having an embassy, not having an ambassador who can represent India's case and raise this issue in the public domain and raise it with the other government is, to my mind, not helpful, which is why the Modi government, despite coming under pressure from various quarters, has not taken that kind of an extreme step, despite relations being pretty bad at present. The fact is that India has alleged violations of the Vienna Convention on consular relations. This is a matter that the ICJ will now adjudicate on, and I think we need to see how the case progresses. There will be plenty of fairly heated argumentation before the court, where Indian and Pakistani lawyers will square off, and that's essentially where the outcome will be produced, not by accentuating a diplomatic standoff between Islamabad and New Delhi. Lavendra Kumar asks, if the army refused to oblige with ICJ, as we know that there are multiple power centers in Pakistan and there is a gap between Pakistani government and the army. Okay, well, I think here I repeat what I said earlier, that there would be enormous diplomatic and political cost at the global level for Pakistan and for the Pakistani military to disregard what the ICJ has requested. So I'd be very surprised if the Pakistani side were to go and do something extreme and reject what the ICJ has requested, quite frankly. I think that they would prefer to try their chances in arguing before the ICJ, where I'm sure Pakistani lawyers are saying that they have a strong case. And I think that's where I would expect action to shift. Abhishek Shukla says, what action should India take to save his life? As I've explained, this entire process of moving the ICJ has been resorted to by India in order to find a definite way to save Kulbhushan Jadhav's life. Pakistan has not responded to has not responded to diplomatic requests that India has made over the past year, and so in a way this was the final option India had to exercise, and it has done so. I should say that this is in some ways a bold and novel step. India has traditionally been quite reticent to invoke international law in a proactive manner, and I would applaud the MEA and the Legal and Treaties Division of the MEA for deciding that this is the fit case to push towards the ICJ, and I am looking forward to the legal arguments and to an eventual judgment that will uphold the principles of the Vienna Convention. Okay, Abraham Thomas asks, does this mean that new cases will be filed against India in cases where India has violated rights and responsibilities? Will this weaken or strengthen our neighborly relations? I think this is a great question, Abraham. Last night when news broke of India moving the ICJ, I noticed many reporters who are part of the WhatsApp diplomatic, the MEA's group, were sort of asking questions about what this might mean for the Kashmir dispute or any other issue that India is not keen to internationalize. And I would say, look, the answer is very simple. This particular case has been taken to the ICJ under a very, very narrow window of a very, very narrow jurisdictional window. Essentially, India and Pakistan, when they, Pakistan signed or issued a statement in 1960, and India did so in 1974, spelling out the circumstances under which they would agree to submit to jurisdiction of the ICJ. India's document, which spells out the terms and conditions under which we would agree to be bound by the ICJ, excludes any case brought to the court by a member of the Commonwealth or a former member of the Commonwealth. So that immediately rules out any case by Pakistan, whether it's on Kashmir, whether it's on an allegation that India may have say violated the Geneva Conventions or violated some other rule. This is exactly what happened in 1999 when a Pakistani aircraft was shot down over the run of Kutch, and Pakistan moved the ICJ for compensation from India, and the ICJ said, look, under the Indian declaration of jurisdiction, of optional jurisdiction, there is no way that the ICJ can exercise jurisdiction over this particular case. So I think that chances of anybody using the Kulbhushan Jadhav case to widen the ambit of India's exposure before the ICJ is likely to hit the brick wall of India's declaration of optional jurisdiction of 1974, which has a number of carve-outs which would exclude the kind of cases that Pakistan would want to bring, or cases that involve that are of a military nature, and so on and so forth. So there are a number of, we've written about this in detail in The Wire. I would urge everybody to read the story that we have up on our site, which spells out the kind of issues which India can go to the court for and which other countries can take India to the court for. And it's a very, very narrow set of issues. I will end this discussion here. Thank you very much for joining us, and as the case evolves and develops, we will come back to you to answer more questions and to explain exactly how the case will proceed. Thank you for watching.